single day.
Get the whole thing.
Say hi, Andy. I'm recording you.
All right, you get the whole thing, right?
I got you.
Ocean City cops are not people.
Yes, they are. You know what's really criminal?
What's that?
Those knee-high socks.
I know, but that's what the brown shirts wore.
Filing hashtag 149491971E filed May 12, 2022, 3:42 and 32 seconds p.m. In the Circuit Court of the 20th Judicial Circuit in and for Charlotte County, Florida. Andrew Bryant Sheets, Appellant, Case No. 21001015 CA Civil Action. V. City of Punta Gorda, Florida Appellee. Appeal from Judgment of the Code Enforcement Board of the City of Punta Gorda, Florida. Case NOS 21-79906, 21-79908, 21-79967, and 21-80024. Appellee's Answer Brief. David M. Levin, ESQ City Attorney, Florida, Bar Number 296,384. Eichard, Merrill, Cullis, Tim Furin and Ginsberg, PA 2033, Main Street, Suite 600, Sarasota, Florida, 34237. Tel, 941-366-8100. Email, d.levin@eichardmerrill.com. Attorney for Appellee. 0153527-1. Preliminary statement. In this answer brief, Andrew Bryant Sheets will be referred to as the appellant, and the City of Punta Gorda, Florida will also be referred to as the city. Applicable portions of the record have been included in the appendix for appellant's initial brief. For the sake of simplicity, the city will refer to the documents in said appendix by AppPG. The transcript of the proceedings before the City of Punta Gorda Code Enforcement Board on July 28, 2021 is included in appendix for appellant's initial brief, beginning on page 1 thereof. The city's appendix for appellee's answer brief will only include selected exhibits introduced into the record before the Code Enforcement Board. Reference to said exhibits will be by City App. PG statement of the case and facts pursuant to the provisions of Section 162.11, Florida Statutes. Appellant has taken a direct appeal from 4 separate orders of the City of Punta Gorda Code Enforcement Board, entered following separate evidentiary hearings conducted on July 28, 2021. Section 162.11, Florida Statutes provides that this appeal shall not be a hearing de novo but shall be limited to appellate review of the record created before the Enforcement Board. In Code Enforcement Case No. 21-79906, the Board upheld the issuance of Citation No. 205,071 to appellant on June 9, 2021, finding appellant to have irreparably 0153504-3-11 violated the provisions of Chapter 26, Section 11.5, Z, Punta Gorda Code, imposing a fine of $1,000 and assessing case costs in the amount of $7.41. App.pg 175-176. Testimony and evidence presented at the hearing demonstrated that appellant was wearing a shirt upon which the word fuck was written, and that such word was considered to be indecent speech legible from within a public space which can potentially be viewed by children under the age of 17. App.pg 37-40, City App.pg 1-4. Chapter 26, Article 11, Section 11.5, Punta Gorda Code provides, unless as otherwise provided for in this article, no person shall erect, display, wear, alter, maintain, or relocate any of the following signs in the city, and such existing signs must be removed. Z. Any sign which contains obscene language or graphics, and any sign containing fighting words or indecent speech which is legible from any public right-of-way or within any public space, and which can potentially be viewed by children under the age of 17. This provision includes signs or flags in or on any vehicle, vessel, or on any apparel and accoutrements. Chapter 26, Article 11, Section 11.4, A. 32. Punta Gorda Code defines the term indecent speech as language or graphics that depict or describe sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards. 0153543-12. In Code Enforcement Case No. 21-79908, the Board upheld the issuance of Citation No. 205,072 to Appellant on June 12, 2021, finding Appellant to have irreparably violated the provisions of Chapter 26, Section 11.5, Z, Punta Gorda Code, imposing a fine of $500 and assessing case costs in the amount of $7.41. App.pg 194-195. Testimony and evidence presented at the hearing demonstrated that Appellant was wearing a shirt upon which the word fuck was written, and that such word was considered to be indecent speech legible from within a public space which can potentially be viewed by children under the age of 17. App.pg 111-114, CITY App.pg 5-6. In Code Enforcement Case No. 21-79967, the Board upheld the issuance of Citation No. 205,081 to Appellant on June 22, 2021, finding Appellant to have irreparably violated the provisions of Chapter 26, Section 11.5, Z, Punta Gorda Code, imposing a fine of $500 and assessing case costs in the amount of $7.41. App.pg 210-211. Testimony and evidence presented at the hearing demonstrated that Appellant was wearing a shirt upon which the word fuck was written, and that such word was considered to be indecent speech legible from within a public space which can potentially be viewed by children under the age of 17. App.pg 137-139, CITY App. PG 7. In Code Enforcement Case No. 21-80,024, the Board upheld the issuance of Citation No. 205,086 to Appellant on June 26, 2021, finding Appellant to have 0153543-13. Irreparably violated the provisions of Chapter 26, Section 11.5, Z, Punta Gorda Code, imposing a fine of $500 and assessing case costs in the amount of $7.41. App.pg 227-228. Testimony and evidence presented at the hearing demonstrated that Appellant was holding a flag upon which the word fuck was written, and that such word was considered to be indecent speech legible from within a public space which can potentially be viewed by children under the age of 17. App.pg 153-154, CITY App.pg 8. Summary of argument. The First Amendment to the United States Constitution, made applicable to the states pursuant to the 14th Amendment, provides in pertinent part, Congress shall make no law, abridging the freedom of speech. Whatever might be said about the freedom of speech, one thing is certain, such freedom is not now, nor has ever been absolute. The fact that a work may not be obscene does not mean the material may not be regulated or prohibited without violating the First Amendment. The U.S. Supreme Court has upheld the constitutionality of prohibitions against indecent speech as defined similarly to that as defined in the city's sign code, even though such speech would not be considered as obscene. A determination as to what constitutes indecent speech under the city's sign code only requires a viewpoint-neutral determination as to whether the words used refer to sexual or excretory activities or organs in an offensive manner as 0153543-14, measured by contemporary community standards. Therefore, the city's sign code, as applied to appellant, is not unconstitutional. The city's sign code places a reasonable time and place restriction on a very limited form of speech in the furtherance of a legitimate and compelling governmental interest, the protection of children from exposure to indecent speech which depicts or describes sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards. The city's sign code is narrowly tailored and leaves open ample opportunities for speech, including indecent speech, so long as such speech is not displayed on signs which are legible from any public right-of-way or within any public space, potentially viewable by children under the age of 17. Accordingly, the city's sign code satisfies the requirements of strict scrutiny, and is thus constitutional. As a practical matter, there are very few words that constitute indecent speech as defined by the city's sign code. These words are well known as offensive by any person of ordinary intelligence. Accordingly, the city's sign code is neither vague nor overbroad, and can be uniformly applied by law enforcement. The city's sign code, and the finding of the city's Code Enforcement Board that appellant has violated the provisions of Chapter 26, Article 11, Section 11.5, Z, Punta Gordas Code, are consistent with the provisions of the First and 14th Amendments to the U.S. Constitution as interpreted by the U.S. Supreme Court. 0153543-15. Argument. IA, restated, the indecent speech provision of the city's sign code is not unconstitutional because it does not ban protected speech and its definition of indecent speech does not extend well beyond what is permitted for the proscription of obscenity. The First Amendment to the United States Constitution, made applicable to the states pursuant to the 14th Amendment, provides in pertinent part, Congress shall make no law, abridging the freedom of speech. Whatever might be said about the freedom of speech, one thing is certain, such freedom is not now, nor has ever been absolute. Miller v. California, 93 S.CT 2607, 2614, 1973. Actions of the drafters of the Constitution support this contention. The First Amendment was ratified on December 15, 1791. Just 7 years later, Congress enacted the Sedition Act of 1798, which provided, in pertinent part, that if any person shall write, print, utter or publish, or shall cause or procure to be written, printed, uttered, or published, or shall knowingly and willingly assist or aid in writing, printing, uttering or publishing any false, scandalous, and malicious writing or writings against the government of the United States or either House of the Congress of the United States, or the President of the United States, with intent to defame the said government, or either House of the said Congress, or the said President, or to bring either of them, into contempt or disrepute, shall be punished by a fine not exceeding $2,000, and by imprisonment not exceeding 2 years. Acts of the 5th Congress of the United States, Statute 2, Chapter 74, 1 Stats. At large 596. 0153543-16. Clearly, if the First Amendment was viewed as being an absolute protection for all speech, the Sedition Act of 1798 would not have been enacted. The U.S. Supreme Court in Roth v. United States, 77 S.CT 1304, 1307-1308, 1957, noted. The guarantees of freedom of expression in effect in 10 of the 14 states which by 1792 had ratified the Constitution, gave no absolute protection for every utterance. 13 of the 14 states provided for the prosecution of libel, and all of those states made either blasphemy or profanity, or both, statutory crimes. In light of this history, it is apparent that the unconditional phrasing of the First Amendment was not intended to protect every utterance. Emphasis added. In 1813 Thomas Jefferson drafted a manual of parliamentary practice for the use of the Senate of the United States. Among Mr. Jefferson's rules of debate within the halls of Congress was the pronouncement, "No person is to use indecent language against the proceedings of the House." Emphasis added. Section 17, Order in Debate, PG 47 https://www.google.com/books/SAAACAAJ, GBPV = 1 in Robertson v. Baldwin, 17 S.CT 326, 329, 1897, the U.S. Supreme Court. Noted. The law is perfectly well settled that the first 10 amendments to the Constitution, commonly known as the Bill of Rights, were not intended to lay down any novel principles of government, but simply to embody certain guarantees and immunities which we had inherited from our English ancestors, and which had, from time immemorial, been subject to certain well-recognized exceptions, arising from the necessities of the case. In incorporating these principles into the fundamental law, there was no intention of disregarding the exceptions. 0153543-17, which continued to be recognized as if they had been formally expressed. Thus, the freedom of speech and of the press, Article 1, does not permit the publication of libels, blasphemous or indecent articles, or other publications injurious to public morals or private reputation. Emphasis added. In Ex Parte Jackson, 96 U.S. 727, 736, 1877, the U.S. Supreme Court upheld the constitutionality of an act of March 3, 1873 wherein Congress declared that, no obscene, lewd, or lascivious book, pamphlet, picture, paper, print, or other publication of an indecent character, nor any letter upon the envelope of which, or postal card upon which indecent or scurrilous epithets may be written or printed, shall be carried in the mail. Emphasis added. In Frawerk v. United States, 39 S.CT 249, 250, 1919, the U.S. Supreme Court noted that the First Amendment was never intended to give immunity for every possible use of language. The court said, "We venture to believe that neither Hamilton nor Madison, nor any other competent person then or later, ever supposed that to make criminal the counseling of a murder within the jurisdiction of Congress would be an unconstitutional interference with free speech." In Gitlow v. People of the State of New York, 45 S.CT 625, 666 to 667, 1925, the U.S. Supreme Court upheld the constitutionality of a New York statute which prohibited language advocating, advising, or teaching the overthrow of organized government by unlawful means. The court noted, "It is a fundamental principle, long established, that the freedom of speech and of the press which is secured by the Constitution, does not 0153543-18 confer an absolute right to speak or publish, without responsibility, whatever one may choose, or an unrestricted and unbridled license that gives immunity for every possible use of language and prevents the punishment of those who abuse this freedom, that a state in the exercise of its police power may punish those who abuse this freedom by utterances inimical to the public welfare, tending to corrupt public morals, incite to crime, or disturb the public peace, is not open to question." In Chaplinsky v. State of New Hampshire, 62 S.CT 766, 769, 1941, the U.S. Supreme Court held, "Allowing the broadest scope to the language and purpose of the 14th Amendment, it is well understood that the right of free speech is not absolute at all times and under all circumstances. There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. It has been well observed that such utterances are no essential part of any exposition of ideas, and are of such light social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Resort to epithets or personal abuse is not in any proper sense communication of information or opinion safeguarded by the Constitution, and its punishment as a criminal act would raise no question under that instrument." In Cohen v. California, 91 S.CT 1780, 1785, 1971, a case wherein Cohen was arrested for disturbing the peace by wearing a jacket in a courthouse with the words "Fuck the Draft" emblazoned on it, the U.S. Supreme Court noted that the First and 14th Amendments have never been thought to give absolute 015350443-19. Protection to every individual to speak whenever or wherever he pleases, or to use any form of address in any circumstances he chooses. In fact, content-based regulation of speech has been upheld in numerous recognized exceptions to the First Amendment. Among these exceptions, in addition to those previously discussed, are advocacy intended, and likely, to incite imminent lawless action, defamation, speech integral to criminal conduct, child pornography, fraud, true threats, and speech presenting some grave and imminent threat the government has the power to prevent. See United States v. Alvarez, 132 S.CT 2537, 2544, 2012. Also among the well-recognized content-based exceptions to the right of free speech is obscenity. In Roth v. United States, 77 S.CT 1304, 1308, 1957, the U.S. Supreme Court stated, at the time of the adoption of the First Amendment, obscenity law was not as fully developed as libel law, but there is sufficiently contemporaneous evidence to show that obscenity, too, was outside the protection intended for speech and press. See also, Ginsburg v. State of New York, 88 S.CT 1274, 1278, 1968, obscenity is not within the area of protected speech or press. Paris Adult Theatre IV Slayton, 93 S.CT 2628, 2633, 1973, this court has consistently held that obscene material is not protected by the First Amendment. Miller v. California, 93 S.CT 2607, 2614, 1973, this much has been categorically settled by the court, that obscene material is unprotected by the First Amendment. 015350443-110. In Miller v. California, 93 S.CT 2607, 2615, 1973, the U.S. Supreme Court announced the now well-accepted obscenity test to be a. Whether the average person, applying contemporary community standards, would find that the work, taken as a whole, appeals to the prurient interest, b. Whether the work depicts or describes, in a patently offensive way, sexual conduct specifically defined by the applicable state law, and c. Whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. The fact that a work may not be obscene according to the test in Miller, however, does not mean the material may not be regulated or prohibited without violating the First Amendment. In United States v. Williams, 128 S.CT 1830, 1836, 2008, the U.S. Supreme Court upheld the constitutionality of a federal statute, 18 U.S.C.A. 2252a, which prohibited a person from knowingly receiving or distributing child pornography. The court described child pornography as sexually explicit visual portrayals that feature children. The court noted, "We have held that a statute which proscribes the distribution of all child pornography, even material that does not qualify as obscenity, does not on its face violate the First Amendment." The City of Punta Gorda Code Enforcement Board found appellant to have violated the provisions of Chapter 26, Section 11.5, Z, Punta Gorda Code on June 9, 2021, Case No. 21-79906, June 12, 2021, Case No. 21-79908, June 22, 2021, Case No. 21-79967, and June 26, 2021, Case No. 21-80024. App.PG 175-176, 194-195, 210-211, 227-228. 0153504-111. Chapter 26, Article 11, Section 11.5, Punta Gorda Code provides, unless as otherwise provided for in this article, no person shall erect, display, wear, alter, maintain, or relocate any of the following signs in the city, and such existing signs must be removed. Z. Any sign which contains obscene language or graphics, and any sign containing fighting words or indecent speech which is legible from any public right-of-way or within any public space, and which can potentially be viewed by children under the age of 17. This provision includes signs or flags in or on any vehicle, vessel, or on any apparel and accoutrements. Chapter 26, Article 11, Section 11.4, A. 32, Punta Gorda Code defines the term indecent speech as language or graphics that depict or describe sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards. The orders of the Code Enforcement Board in each case involving appellant expressly found that appellant displayed signs involving indecent speech in a manner prohibited by Chapter 26, Article 11, Section 11.5, Z, Punta Gorda Code. App.pg 175 to 176, 194 to 195, 210 to 211, 227 to 228. It was not alleged that appellant's signs included obscene language or graphics, or fighting words. Just as the court in Williams found that a federal statute prohibiting child pornography that was not obscene under the Miller test was nevertheless constitutional, the city's prohibition against the display of indecent speech, which is 0153504-112, legible from any public right-of-way or within any public space, and which can potentially be viewed by children under the age of 17, is not unconstitutional on its face. In FCC v. Pacifica Foundation, 98 S.CT 3026, 1978, the U.S. Supreme Court determined that the Federal Communications Commission has the power to regulate a radio broadcast that was deemed to be indecent but not obscene. The FCC relied upon 18 U.S.C. 1464, 1976 ed., which provides, whoever utters any obscene, indecent, or profane language by means of radio communication shall be fined not more than $10,000 or imprisoned not more than 2 years, or both. Pacifica at 3031. Referring to the statute at issue, the court noted, the words obscene, indecent, or profane are written in the disjunctive, implying that each has a separate meaning. Pacifica at 3036. As noted above, from the earliest days of our nation, prohibitions against indecent speech were not considered to be contrary to the First Amendment. However, until Pacifica, the U.S. Supreme Court had not considered a definition for the term indecent. In FCC v. Pacifica Foundation, 98 S.CT 3026, 1978, the U.S. Supreme Court considered an FCC determination that a 2 p.m. broadcast by a radio station owned by Pacifica of a monologue by comedian George Carlin entitled Filthy Words 0153504-113 violated the provisions of 18 U.S.C. 1464, 1976 ed. Carlin's monologue included the words fuck and cunt. Pacifica at 3041. The U.S. Supreme Court upheld the constitutionality of FCC's definition of the term indecent speech as language which refers to sexual or excretory activities and organs in a way that is patently offensive as measured by contemporary community standards. Pacifica at 3031. The court noted that while prurient appeal is an element of the term obscene, not so with respect to indecent speech. Pacifica at 3036. Even George Carlin joked the words fuck and cunt will curve your spine, grow hair on your hands. Pacifica at 3041. Referring to the term indecent, the court noted, Webster defines the term as a, altogether unbecoming contrary to what the nature of things or what circumstances would dictate as right or expected or appropriate, hardly suitable, unseemly. Webster's Third New International Dictionary, 1966. Pacifica at 3046, N14. The court further noted, these words offend for the same reasons that obscenity offends. Their place in the hierarchy of First Amendment values was aptly sketched by Mr. Justice Murphy when he said, such utterances are no essential part of any exposition of ideas, and are of such light social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Pacifica at 3039. 0153543-114. Also referring to Webster's, it should be noted that the word fuck is defined as, to engage in sexual intercourse. The term is generally regarded as offensive to prevailing notions or propriety. The word cunt is defined as, 1. The vulva or vagina, 2. Sexual intercourse with a woman. Webster's New World College Dictionary, 4th ed. The online Cambridge Dictionary provides that the word cunt is offensive for the vagina. https://dictionary.cambridge.org/a/dictionary/english/cunt. Accordingly, the city's sign code is not unconstitutional because it extends the definition of obscenity. The sign code is constitutional because its definition of indecent speech is consistent with terminology approved by the U.S. Supreme Court. Furthermore, appellant's use of the words fuck and cunt represents indecent speech in accordance with the accepted definitions, and is deemed to be offensive. Thus, as determined by the city's Code Enforcement Board, appellant's use of such terms came within the prohibition provided in the city's sign code. Before moving on, it is necessary to address in more detail the U.S. Supreme Court's decision in Cohen v. California, 91 S.Ct. 1780, 1971. Said case is heavily relied upon by appellant in his initial brief and otherwise, to support his ubiquitous use of the F-word. Yes, Cohen's prosecution for having the words fuck the draft on his jacket within a courthouse was overturned by the U.S. Supreme Court. 0153543-115. However, if one takes the time to read the court's opinion, it will become clear that the court did not sanction the unbridled use of the term as an incident of free speech. Cohen was not arrested under any law making it unlawful to utter or display the word fuck. Cohen was convicted of a City of Los Angeles ordinance which prohibits maliciously and willfully disturbing the peace or quiet of any neighborhood or person, by offensive conduct. Emphasis added. In other words, Cohen was convicted of disturbing the peace. Cohen at 1783. The U.S. Supreme Court noted, the defendant did not engage in, nor threaten to engage in, nor did anyone as a result of his conduct in fact commit or threaten to commit any act of violence. The defendant did not make any loud or unusual noise, nor was there any evidence that he uttered any sound prior to his arrest. Cohen at 1784. The court further stated, at least so long as there is no showing of an intent to incite disobedience to or disruption of the draft, Cohen could not, consistently with the First and 14th Amendments, be punished for asserting the evident position on the inutility or immorality of the draft his jacket reflected. Cohen at 178-5. Most notably, the U.S. Supreme Court left the door open for a state to excise the subject's scurrilous epithet from the public discourse, acting as guardians of public morality to remove the offensive word from the public vocabulary. 2. 0153543-116. Do so, however, it will be necessary for the state to employ a rationale other than disturbance of the peace. The court stated, we have been shown no evidence that substantial numbers of citizens are standing ready to strike out physically at whoever may assault their sensibilities with execrations like that uttered by Cohen. Cohen 1787. IB, restated, the city's sign code as applied to appellant is not unconstitutional because it is not viewpoint discriminatory in violation of the First Amendment. Appellant's argument depends upon a falsehood not reflected in the record of the proceedings before the city's Code Enforcement Board, that is, Appellant was cited for the message displayed on his shirt, flags, and signs. It is abundantly clear that appellant was cited for his use of indecent words. For example, with respect to citation number 205,071, case no 21-79906, issued on June 9, 2021, City of Punta Gorda Police Officer William Gorman testified as follows. Q and I'll show you city's exhibit number 7. And what is Mr. Sheets wearing? A. At that time, a black t-shirt with block-style white lettering. Q. Is the photo an accurate depiction of the scene as you saw it at that time? A. Yes, sir, it is. Q. And is Mr. Sheets' shirt considered to be apparel? A. Yes, sir. Q. Is it your understanding that apparel upon which words have been printed constitutes a sign as that term is defined by the city's sign standards? A. Yes, sir, it is. Q. Did Mr. Sheets' shirt contain indecent speech as that term is defined by the city's sign standards? 0153504-3-117. A. Yes, sir, it did. Q. And what word or words on Mr. Sheets' shirt did you find to be indecent speech as that term is defined by the city's sign standards? A. On the back portion of the shirt, as we look at it there, it would be the white letters, top word, again, phonetic spelling of the top word would be F as in Frank, U as in Union, C as in Charles, and K, King app.pg. 39-40. With respect to citation number 205,072, case no 21-79909, issued on June 12, 2021, City of Punta Gorda Police Officer Russell Riorino testified as follows. Q. I'll show you city's exhibit number 5 and ask what Mr. Sheets was wearing as shown in this photo. A. He's wearing a black shirt that reads "Fuck the police." Q. And is this photo an accurate depiction of the scene as you saw it? A. It is. Q. And is Mr. Sheets' shirt considered to be apparel? A. Yes, sir. Q. Is it your understanding that apparel upon which words have been printed constitute a sign as that term is defined by the city's sign standards? A. Yes, sir. Q. Did Mr. Sheets' shirt contain indecent speech as that term is defined by the city's sign code standards? A. It did. Q. And what word or words on Mr. Sheets' shirt did you find to be indecent speech as that term is defined by the city's sign standards? A. The word fuck. app.pg 113-114. With respect to citation number 205,081, case no 21-79967, issued on June 22, 2021, City of Punta Gorda Police Officer Joshua Gerard testified as follows. Q. Is this photo an accurate depiction of the scene as you saw it? A. Yes, it is. Q. And what was Mr. Sheets wearing? A. He was wearing a black t-shirt with the words "Fuck the police" in bold white lettering. 0153504-3-118. Q. Is Mr. Sheets' shirt considered to be apparel? A. Yes. Q. And is it your understanding that apparel upon which words have been printed constitutes a sign as that term is defined by the city's sign standards? A. Yes. Q. Did Mr. Sheets' shirt contain indecent speech as that term is defined by the city's sign standards? A. It did. Q. And, again, specifically what word or words on Mr. Sheets' shirt did you find to be indecent speech as that term is defined? A. Fuck. app.pg 138-139. With respect to citation number 205,086, case no 21-80,024, issued on June 26, 2021, City of Punta Gorda Police Officer Joshua Gerard testified as follows. Q. And was Mr. Sheets holding a sign as that term is defined by the city's sign standards? A. Yes. Q. Is it your understanding that a flag is a sign as that term is defined by the city's sign standards? A. Yes. Q. What word or words on Mr. Sheets' flag did you find to be indecent speech as that term is defined in the city's sign standards? A. Fuck. App.pg 153 to 154. The case at bar is distinguishable from the facts in the cases cited in appellant's initial brief. In Iancu v. Brunetti, 139 S.CT 2294, 2019, the U.S. Supreme Court held that a clause within a federal patent and trademark statute prohibiting registration for marks that are immoral or scandalous, was facially invalid. The court found, the Lanham Act permits registration of marks that champion society's sense of rectitude and morality, but not marks that denigrate those concepts. Iancu at 2399. Application of the statute thus requires a 0153504-119 viewpoint-based determination of the messages sought to be protected by a trademark. Similarly, in Madl v. Tam, 137 S.CT 1744, 2017, the court found that a clause within a federal patent and trademark statute prohibiting registration for marks that might disparage any persons, living or dead, was facially invalid. The disparagement clause prohibits the registration of a trademark which may disparage persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Madl at 1753. The statute thus requires a viewpoint-based determination by the Patent and Trademark Office. In contrast, the determination as to what constitutes indecent speech under the city's code only requires a viewpoint-neutral determination as to whether the words used refer to sexual or excretory activities or organs in an offensive manner as measured by contemporary community standards. It also requires a viewpoint-neutral determination as to whether the sign is legible from any public right-of-way or within any public space, and whether it can potentially be viewed by children under the age of 17. Accordingly, consistent with the U.S. Supreme Court's holding in Pacifica, the city's sign code, as applied to appellant, is not unconstitutional because it is viewpoint neutral. 0153504-120. IC, restated, the city's sign code survives strict scrutiny. Similar to the FCC regulation held to be constitutional in Pacifica, the provisions in the city's sign code relating to indecent speech are content-based. Also similar to the FCC's actions in Pacifica, the city's regulations were enacted pursuant to a compelling governmental interest, the protection of children. In Ginsburg v. State of New York, 88 S.CT 1274, 1968, the U.S. Supreme Court recognized that government has an interest to protect the welfare of children and to see that they are safeguarded from abuses which might prevent their growth into free and independent well-developed men and citizens. Ginsburg at 1281. See also, Erdnojnik v. City of Jacksonville, 95 S.CT 2268, 2274, 1975, it is well settled that a state or municipality can adopt more stringent controls on communicative materials available to youths than on those available to adults. FCC v. Pacifica Foundation, 98 S.CT 3026, 3044, 1978, concurring opinion of Justice Powell, the court has recognized society's right to adopt more stringent controls on communicative materials available to youths than on those available to adults. This recognition stems in large part from the fact that a child is not possessed of that full capacity for individual choice which is the presupposition of First Amendment guarantees. Thus, children may not be able to protect themselves from speech which, although shocking to most adults, generally may be avoided by the unwilling through the exercise of choice. Bethel School District. 0153504-121. Number 403 v. Fraser, 106 S.CT 3159, 3164-3165, 1986. This court's First Amendment jurisprudence has acknowledged limitations on the otherwise absolute interest of the speaker in reaching an unlimited audience where the speech is sexually explicit and the audience may include children, We have also recognized an interest in protecting minors from exposure to vulgar and offensive spoken language. Sable Communications of California Incorporated v. FCC, 109 S.CT 2829, 2836, 1989, Government has a legitimate interest in protecting children from exposure to indecent dial-A porn messages. We have recognized that there is a compelling interest in protecting the physical and psychological well-being of minors. This interest extends to shielding minors from the influence of literature that is not obscene by adult standards. Denver Area Educational Telecommunications Consortium v. FCC, 116 S.CT 2374, 2386, 1996. The provision before us comes accompanied with an extremely important justification, one that this court has often found compelling: the need to protect children from exposure to patently offensive sex-related material. It should be noted that on pages 13 and 18 of appellant's initial brief, appellant argues that Monoy Area School District v.BL. By and through Levy, 141 S.CT 2038, 2021, makes clear children have a constitutional right to use offensive language themselves in communicating with other children. The court made no such finding. The case involved whether the school had the right to punish 0153504-3-122 BL for her use of vulgar language under the circumstances presented in the facts of that case. The court did expressly state that BL uttered the kind of pure speech to which, were she an adult, the First Amendment would provide strong protection. Emphasis added. The court clearly recognized that as a minor, BL did not have the same rights as an adult. The court did not say she had a right to use offensive language in the presence of other children. The city's prohibition against signs displaying indecent speech is narrowly tailored to apply only to signs which are legible from a public right-of-way or within a public space, and which can potentially be viewed by children under the age of 17. The city's prohibition does not have any effect upon spoken words. The city's prohibition does not prohibit speakers from going door to door to proselytize their views. They may distribute literature on a public street or place, or through the mail. They may contact residents by telephone. They may communicate through any number of social media outlets available within the city, including the city's own website. Persons may include indecent speech on signs that are not legible from a public right-of-way or within a public space. In Pacifica, the U.S. Supreme Court upheld the FCC's action in view of the fact that the indecent speech complained of was broadcast at 2 p.m. in the afternoon, a time of day when there is a reasonable risk that children may be in the audience. The court further noted, however, that George Carlin's indecent monologue would 0153504-3-123 not have been actionable if it had been broadcasted later in the evening when children would not reasonably be expected to be in the audience. Pacifica at 3032. Thus, the city's prohibition would not prevent the use of signs displaying indecent speech if used at times or at locations when or where the presence of children under the age of 17 would not reasonably be anticipated. In Frisbee v. Schultz, 108 S.CT 2495, 2503, 1988, the U.S. Supreme Court held that a law is narrowly tailored if it targets and eliminates no more than the exact source of the evil it seeks to remedy. The city's sign code only targets and eliminates signs displaying indecent speech which are legible from a public right-of-way or within a public space, and which can potentially be viewed by children under the age of 17. These regulations are the minimum necessary to protect children from indecent speech, as defined, without completely eliminating the display of such speech to adults. In essence, the city's sign code places a reasonable time and place restriction on indecent speech. In Snyder v. Phelps, 131 S.CT 1207, 1218, 2011, the U.S. Supreme Court noted, even protected speech is not equally permissible in all places and at all times, it is subject to reasonable time, place, or manner restrictions. See also, United States v. Grace, 103 S.CT 1702, 1707, 1983, 1, we have regularly. 1. It is interesting to note that in Grace, the U.S. Supreme Court upheld the constitutionality of a federal statute which prohibits, among other things, the display of any flag, banner, or device designed or adapted to bring into public. 015350043-124. Rejected the assertion that people who wish to propagandize protests or views have a constitutional right to do so whenever and however and wherever they please. In Reno v. American Civil Liberties Union, 117 S.CT 2329, 1997, while the U.S. Supreme acknowledged the governmental interest in protecting children from harmful materials, sufficient technological safeguards were available to protect children from the danger of accidental exposure. The court noted that there is currently available user-based software which presents a reasonably effective method by which parents can prevent their children from accessing sexually explicit and other material which parents believe is inappropriate for their children. Reno at 2347. Thus, the court found that a complete ban on sexually explicit material was not necessary or reasonable in order to protect children. ID. In Pacifica, the broadcaster argued that children could be protected if a parent turned off the radio when the parent heard indecent language. Pacifica at 3040. Rejecting that argument, the U.S. Supreme Court noted that was like saying that the remedy for an assault is to run away after the first blow. One may hang up on an indecent phone call, but that option does not give the caller a constitutional immunity or avoid a harm that has already taken place. ID. Notice any party, organization, or movement in the United States Supreme Court building and on its grounds. Grace at 1704. 015350043-125. Unfortunately, there is no reasonably effective method by which parents can protect their children from viewing indecent speech displayed on a sign which is legible from any public right-of-way or within any public space. Accordingly, the city's sign code is narrowly tailored to further the city's legitimate and compelling interest. It satisfies the requirements of strict scrutiny, and thus is constitutional. I.D.1, restated, the city's sign code provides fair notice because its definition of indecent speech is not subjective or uncertain. In Hill v. Colorado, 120 S.CT 2480, 2499, 2000, the U.S. Supreme Court noted, speculation about possible vagueness in hypothetical situations not before the court will not support a facial attack on a statute when it is surely valid in the vast majority of its intended applications. Long ago, the U.S. Supreme Court in Winters v. People of State of New York, 68 S.CT 665,670-671, 1948, stated, acts of gross and open indecency or obscenity, injurious to public morals, are indictable at common law, as violative of the public policy that requires from the offender retribution for acts that flaunt accepted standards of conduct. The court noted crimes described by such words as obscene, lewd, lascivious, filthy, indecent, or disgusting are well understood through long use in the criminal law. Emphasis added. 0153543-126. The U.S. Supreme Court in Pacifica had no concern regarding the definitiveness of the term indecent speech as articulated by the FCC, and it should be noted that the city's definition is modeled after that of the FCC. In Denver Area Educational Telecommunications Consortium v. FCC, 116 S.CT 2374, 2390, 1996, the U.S. Supreme Court considered the argument that the definition of indecent materials is too vague. The court nevertheless upheld the constitutionality of the definition, stating, the language, while vague, attempts to identify the category of materials that Justice Stewart thought could be described only in terms of I know it when I see it. As noted above, Chapter 26, Article 11, Section 11.4, A. 32, Punta Gorda Code defines the term indecent speech as language or graphics that depict or describe sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards. Emphasis added. The highlighted phrase in the city's definition gives people of ordinary intelligence a reasonable opportunity to understand what conduct it prohibits. For example, no one of ordinary intelligence would consider as offensive language which describes sexual activity as intercourse or coitus. On the other hand, most persons of ordinary intelligence would understand that the word fuck, a word the dictionary defines as describing sexual activity, is offensive. 01535043127. Similarly, no one of ordinary intelligence would consider as offensive language which describes a sexual organ as a vagina. But clearly most would consider the word cunt as offensive. There can be no doubt that the words used by the appellant on his signs were known to him as indecent, as that term is defined by the city's sign code. There can be no doubt that anyone of ordinary intelligence would similarly understand that such words were indecent, as that term is defined by the city's sign code. Even George Carlin, in his monologue, Filthy Words, suggests that the list of words which would fit the city's definition of indecent speech boils down to just 3 words, 2 of which were the basis of the appellant's citations. Point 2. These are words that parents have forever told children never to repeat. They are words that would result in punishment if repeated in school. They are words well familiar to persons of ordinary intelligence. In my day, if uttered, they would result in a mouth-washing with soap and a spanking. In United States v. Williams, 128 S.CT 1830, 1846, 2008, the U.S. Supreme Court noted, "What renders a statute vague is not the possibility that it will sometimes be difficult to determine whether the incriminating fact it establishes has been proved, but rather the indeterminacy of precisely what that fact is. Thus, we have struck down statutes that tied criminal culpability to a transcript of the monologue which was the basis of the U.S. Supreme Court's opinion in FCC v. Pacifica Foundation, 98 S.CT 3026, 1978, was included by the court as an appendix. Pacifica at 3041. 0153504-128. To whether the defendant's conduct was annoying or indecent, wholly subjective judgments without statutory definitions, narrowing context, or settled legal meanings. Emphasis added. In Ashcroft v. American Civil Liberties Union, 124 S.CT 2783, 2783, 2004, the U.S. Supreme Court stated, "Content-based prohibitions, enforced by severe criminal penalties, have the constant potential to be a repressive force in the lives and thoughts of a free people." Emphasis added. To avoid the concerns expressed by the U.S. Supreme Court in the 2 cases cited above, the city's sign code was drafted to include a specific definition for the term indecent speech, consistent with language previously approved by the court. Further, violation of the city's sign code is not punishable by severe criminal penalties. Violators of the city's sign code are issued citations pursuant to the provisions of Chapter 9A, Section 9A10, Punta Gorda Code. Section 9A10, C, Punta Gorda Code, provides, "The fine for a first offense of a violation to be enforced by means of a citation shall be $25.00. Thus, violations of the city's sign code are not punishable by the type of severe criminal penalties that may cause a chilling effect upon the exercise of free speech. Additionally, pursuant to the provisions of Section 9A10, C, Punta Gorda Code, code compliance officers shall have the discretion to issue a written warning instead of a citation for a first offense. This is precisely how the appellant's violation was handled. The appellant was issued a warning on June 7. 0153504-129. 2021 for displaying a sign with indecent speech within the city of Punta Gorda. App.pg 40. Thus, when the appellant was issued citation number 205,071, case no 21-79906, issued on June 9, 2021, he was well aware that his sign contained words that were prohibited under the city's sign code. Thus, the city's definition of indecent speech is not impermissibly vague. It provides fair notice of the type of speech, location, and time that such speech is prohibited. I.D.2, restated, the city's sign code's indecent language provision is not impermissibly vague because its terms do not create a high probability of inconsistent enforcement. Appellant's argument regarding inconsistent enforcement of the city's sign code begins with a false premise, that the term indecent speech is not defined. As discussed above, the city's sign code provides a clear definition of indecent speech in terms found accepted by the U.S. Supreme Court in Pacifica. In Hill v. Colorado, 120 S.CT 2480, 2499, 2000, the U.S. Supreme Court noted, because we are condemned to the use of words, we can never expect mathematical certainty from our language. As always, enforcement requires the exercise of some degree of police judgment. Such a requirement for the exercise of judgment by law enforcement does not render an ordinance impermissibly vague. 0153504-130. In United States v. Williams, 128 S.CT 1830, 1845, 2008, the U.S. Supreme Court stated, perfect clarity and precise guidance have never been required even of regulations that restrict expressive activity. Appellant cites Grain v. City of Rockford, 92 S.CT 2294, 1972, in support of its argument that laws must provide explicit standards for those who apply them. In that case, the City of Rockford's anti-noise ordinance was challenged as being impermissible. 3. The U.S. Supreme Court upheld the city's anti-noise ordinance finding. The words of the Rockford Ordinance are marked by flexibility and reasonable breadth, rather than meticulous specificity, but we think it is clear what the ordinance as a whole prohibits. As always, enforcement requires the exercise of some degree of police judgment, but, as confined, that degree of judgment here is permissible. The ordinance defines boundaries sufficiently distinct for citizens, policemen, juries, and appellate judges. Grained at 2300-2302. Appellant also cites a Florida case, Spears v. State of Florida, 337 So.2d 977, 980, FLA 1976, in support of the proposition, nobody can be punished under a statute purporting to outlaw spoken words, if the statute would be unconstitutional as applied to anybody. In that case, Spears was convicted of a statute that prohibited any indecent or obscene language. 3. The City of Rockford's ordinance provided, in pertinent part, no person, while on public or private grounds adjacent to any building in which a school or any class thereof is in session, shall willfully make or assist in the making of any noise or diversion which disturbs or tends to disturb the peace or good order of such school session or class thereof. Grained at 2298. 0153504-131. The statute in Spears defined neither the terms indecent nor obscene. Accordingly, the Spears case is factually distinguishable from the case at bar where both terms are clearly defined by the City of Punta Gordas sign code. Accordingly, consistent with the court's finding in Grained, and the previously cited opinions, in view of the fact that the city's sign code provides a specific definition for the term indecent speech, persons of ordinary intelligence, including law enforcement personnel, have fair notice of what is prohibited. Thus, the terms do not create a high probability of inconsistent enforcement. I.D.3, restated, the city's sign code is not overbroad because its meanings will not cause some residents to preemptively self-censor their constitutionally protected speech. Appellant principally relies upon the U.S. Supreme Court's decision in Reno v. American Civil Liberties Union, 117 S.CT 2329, 1997, in support of his argument that the city's sign code is overbroad. Reno is distinguishable from the case at bar in three major ways. First, and most significantly, the federal statute challenged in Reno Communications Decency Act of 1996, CDA, used the terms indecent and patently offensive to prohibit the transmission of certain images and communications over the Internet to recipients under the age of 18. However, the statute defined none of these terms. Reno at 2347. The U.S. Supreme Court noted, the general, undefined terms indecent and patently offensive cover large amounts of non-pornographic material with serious educational or other value. ID 0153543-132. In the case at bar, the city's sign code clearly defines the term indecent speech, and unlike the statute in Reno, the city's sign code does not use the term patently offensive to describe a category of communications that are prohibited. Secondly, in an effort to protect children from undesirable exposure of adult content over the Internet, the federal statute prohibits all such communication. The U.S. Supreme Court noted, it is true that we have repeatedly recognized the governmental interest in protecting children from harmful materials, but that interest does not justify an unnecessarily broad suppression of speech addressed to adults. Reno at 2344. The court stated, the breadth of this content-based restriction of speech imposes an especially heavy burden on the government to explain why a less restrictive provision would not be as effective as the CDA. It has not done so. Reno at 2348. Thirdly, the federal statute challenged in Reno was a criminal statute. The court noted, the severity of criminal sanctions may well cause speakers to remain silent rather than communicate even arguably unlawful words, ideas, and images. Reno at 2344. The city's sign code does not contain any of the three deficiencies identified by the court with respect to the CDA. The city's sign code clearly defines the prohibited language. The city's sign code does not prohibit all uses of indecent speech and leaves open ample opportunities for speakers to use the prohibited. 0153543-133. Language other than in the manner prohibited, and violation of the city's sign code is not a crime. It is unlikely that the minor fines imposed upon violators will deter the exercise of free speech. Clearly, it did not deter appellant. In United States v. Williams, 128 S.CT 1830, 1838, 2008, the U.S. Supreme Court warned that there should not be a rush to judgment when considering invalidating a statute on the basis of overbreadth. The court stated, according to our First Amendment overbreadth doctrine, a statute is facially invalid if it prohibits a substantial amount of protected speech. The doctrine seeks to strike a balance between competing social costs. On the one hand, the threat of enforcement of an overbroad law deters people from engaging in constitutionally protected speech, inhibiting the free exchange of ideas. On the other hand, invalidating a law that in some of its applications is perfectly constitutional, particularly a law directed at conduct so antisocial that it has been made criminal, has obvious harmful effects. In order to maintain the appropriate balance, we have vigorously enforced the requirement that a statute's overbreadth be substantial, not only in an absolute sense, but also relative to the statute's plainly legitimate sweep. Invalidation for overbreadth is strong medicine that is not to be casually employed. The city's sign code relating to indecent speech, as defined, is not overbroad. It has been narrowly drafted to avoid the regulation of a substantial amount of protected speech. Therefore, the city's sign code is valid. 2. Restated, the words appellant displayed constituted descriptions of sexual activity or organs in the manner contemplated by the city's sign code, and thus the Code Enforcement Board did not violate the First and 14th Amendment to the U.S. Constitution in applying the sign code to appellant when it found him in violation. 0153543-134. In his initial brief, appellant concedes, there is no dispute as to Sheets' actions or the language he displayed. Initial brief at page 28. Appellant acknowledges that he displayed the words fuck and cunts. Initial brief at page 29. At the July 28, 2021 hearing before the Code Enforcement Board, appellant offered no testimony or evidence to dispute the testimony of the city's witnesses that appellant displayed or wore signs containing indecent speech which was legible from any public right-of-way or within any public space, and which could potentially be viewed by children under the age of 17. Even if appellant introduced such evidence, that would not be legally sufficient to overturn the finding of the Code Enforcement Board. In City of Sarasota v. Pleasures 2 Adult Video Incorporated, 799 So.2d 325, 327, FLA 2nd DCA 2001, the court stated, when a party seeks review of an administrative action in a circuit court, the circuit court must determine the following: 1. Whether procedural due process was accorded, 2. Whether the essential requirements of the law were observed, and 3. Whether there was competent, substantial evidence to support the administrative findings and judgment. A circuit court departs from the essential requirements of the law when it substitutes its judgment for that of the hearing officer, reweighs the evidence, or re-evaluates the credibility of the evidence. Emphasis added. In Dusso v. Metropolitan-Dade County Board of County Commissioners, 794 So.2d 1270, 1276, FLA 2001, the Florida Supreme Court held, while contrary evidence may be relevant to the wisdom of the decision, it is irrelevant to the 0153504-135 lawfulness of the decision. As long as the record contains competent substantial evidence to support the agency's decision, the decision is presumed lawful and the court's job is ended. Thus, contrary to appellant's argument, the Code Enforcement Board lawfully found appellant to be in violation of the city's sign code. Appellant would have this court rewrite the definition of indecent speech as contained in Chapter 26, Article 11, Section 11.4, A, 32, Punta Gordas Code. Appellant argues that the phrases he displayed do not constitute descriptions of sexual activity or organs. Appellant lists the phrases he displayed as fuck Biden, fuck Trump, the city council members are cunts, fuck the police, and fuck policing for profit. Initial brief at page 29. As noted above, according to dictionaries, the words fuck and cunt clearly describe sexual activity and organs, respectively, in an offensive manner. Like putting a wolf in sheep's clothing, appellant argues that the words lose their meaning when associated with additional words. There may be some merit to that argument if minors are taken out of the equation. Adults may have the linguist's skills to appreciate that the phrase fuck Biden is not to be given its literal interpretation. However, the city's sign code is not intended to protect adults from indecent speech, it is clearly intended to protect minors, a well-recognized compelling governmental interest. 0153504-3-136. It is interesting to note that appellant chose to cite the decision of the Federal District Court in Baker v. Glover, 776 F.Sup. 1511, D.C.M.D. Alla 1991. That case involved another one of George Carlin's self-described filthy words which appeared on a bumper sticker. .4 Pacifica at 3041. The court in Baker went beyond what might be considered as necessary to explain the scope of its decision. The court stated, before closing, the court would note the limited nature of its holding today. Section 13A12-131 is expressly limited in its terminology and application to obscene language descriptive of sexual or excretory activities. Emphasis added, the law does not address indecent or profane language which may be harmful to children. The court's holding, therefore, is limited to the specific conclusion that Baker's bumper sticker cannot be considered obscene and thus falling within the statute's ban, without running afoul of the First Amendment. This court is therefore not confronted with a much different and more difficult issue of how far the government may go in regulating offensive or sexually explicit but non-obscene speech to which minors may be exposed, whether Baker's bumper sticker could be constitutionally banned by another state statute which, in order to protect minors, sought specifically to regulate or ban vehicular stickers that are indecent or profane but not obscene is an issue the court does not reach. Emphasis added. Baker at 1517. The words appellant used on his signs clearly constituted indecent speech as that term is defined by the city's sign code. The city's Code Enforcement Board properly found that appellant displayed his signs at times and locations where they could potentially be viewed by children under the age of 17. Therefore, the code. 4 Baker put a bumper sticker on his truck which read, "How's my driving? Call 1-800-EAT-SHIT. 0153504-3-137. Enforcement Board did not violate the First and 14th Amendments to the U.S. Constitution when the city's sign code was applied to appellant. Conclusion: the provisions of the City of Punta Gordas sign code which prohibit the display or wearing of any sign containing indecent speech which is legible from any public right-of-way or within any public space, which can potentially be viewed by children under the age of 17, and which provides a clear definition for the term indecent speech, is a valid exercise of the city's police power. The regulation provides proper notice to persons of ordinary intelligence as to what is prohibited by the sign code. The regulation serves a legitimate and compelling interest, the protection of children, and has been narrowly tailored to be consistent with the requirements of strict scrutiny. The city's sign code, and the finding of the city's Code Enforcement Board that appellant has violated the provisions of Chapter 26, Article 11, Section 11.5, Punta Gorda Code, are consistent with the provisions of the First and 14th Amendments to the U.S. Constitution as interpreted by the U.S. Supreme Court. Accordingly, the final orders before this court for review are correct and should be affirmed. 0153504-3-138. Respectfully submitted. /s/David M. Levin David M. Levin, ESQ City Attorney Florida Bar Number 296384 Eichard Merrill Cullis Tim Fuhren and Ginsburg, PA 2033 Main Street Suite 600 Sarasota Florida 34237 Tel, 941-366-8100 Email, levin@eichardmerrill.cornc and eichardmerrill.com Attorney for Appellee. Certificate of Service: I hereby certify that a true copy of the foregoing was sent via the e-file portal for filing and by electronic mail to Fairs Heindel, ESQ at PMHEINDL@heindllaw.com on this 12th day of May, 2022.